കേൾക്കുന്നുണ്ടോ?
ഉണ്ട് സർ, കേൾക്കുന്നുണ്ട്.
ഓക്കെ.
സുധാകാന്തൻ
സാർ കേൾക്കാം സാർ,
കേൾക്കാമല്ലോ.
കേൾക്കാം.
Honorable Principal District Judge and Chairman District Legal Services Authority, Palakkad, Dr. B. Kalam Pasha sir, Honorable Judicial Officers of Palakkad District Judiciary, respected Professor Dr. J. Mohan Gopal sir, learned members of the bar, a very good evening and warm welcome to this webinar on constitutional vision of justice. As we all know, this year India is celebrating the Platinum Jubilee of our Constituent Assembly, which met for the first time on 9th of December 1946 for framing the Constitution of India. To commemorate this event and also to remind ourselves of the fundamental values of our Constitution, the District Legal Services Authority, Palakkad, has organized this webinar. At this juncture, the primary challenge before us is how we, being part of the district judiciary, working on the trial side of the justice dispensing system, is capable of implementing the fundamental values enshrined under our constitution, so as to achieve the objective, so as to achieve the constitutional vision of justice. For effectively addressing this challenge, our Honorable Principal District Judge and Chairman District Legal Services Authority, Dr. B. Kalam Pasha sir, has taken the keen interest and initiative to organize this webinar. Without the support and guidance of our Honorable Principal District Judge, this webinar would not have been possible in its present form. I take this opportunity to warmly welcome our Honorable Principal District Judge and Chairman District Legal Services Authority, Palakkad, Dr. B. Kalam Pasha sir, to this webinar. Today, we are extremely fortunate to have with us Professor Dr. G. Mohan Gopal sir, who is a leading voice in judicial reforms and justice in India. As we all know, sir has done his master's and doctorate in law from the Harvard Law School, USA, and has been the head of several prestigious institutions inside and outside India, including the National Judicial Academy, Bhopal, under the Honorable Supreme Court of India, for the period from 2006 to 2011. It is my privilege to welcome Professor Dr. J. Mohan Gopal sir to this webinar. Today, we have with us all the judicial officers of Palakkad district who have taken time out of their busy schedule to attend this webinar. I warmly welcome each one of the judicial officers who are attending this webinar. Also, we have with us the esteemed members of the bar who are viewing this webinar in the YouTube live cast. I warmly welcome each one of the members of legal fraternity to this webinar. I hope that this webinar will be a humble tribute to the founding fathers of the Constitution of India. With this, may I humbly request our Honorable Principal District Judge and Chairman, District Legal Services Authority, Dr. B. Kalam Pasha, sir, to kindly inaugurate this webinar. Sir.
Dr. Mohan Gopal, the former Director, National Judicial Academy, Mr. Sudhakant, Chief Judicial Magistrate, Palakkad, Mrs. Anupama, Secretary, District Legal Services Authority, my sister and brother officers, all the persons viewing this program online, ladies and gentlemen. As we all know, this is the Platinum Jubilee of the Constituent Assembly, which met for the first time on 9th December 1946. We have with us an esteemed speaker in the form of Dr. Mohan Gopal. We are lucky to have such a personality for the district program. That is why we are webcasting it live in YouTube. Such a personality who requires no introduction at all. He was the director of the National Judicial Academy. Even such a background, by his his performance, he acquired the reputation of all judicial minds by his deep knowledge, erudition, and also skill of communication. Even in such a background, I am undertaking a risk of making an introduction with an attempt to plow the field for the seeds to grow. The seeds are not with me. They are with Dr. Mohan Gopal, and he knows better to sow them at the right time and the right place in the right manner. Without a word about him, I would be failing in my duties. This is the 30th year of my service as a judge. In my career, in my past service as a judge, I have seen this person who lifted the National Judicial Academy to a great different level. If I will be ungrateful if I did not mention about at least one particular program conducted by him. I have attended many programs conducted by the National Judicial Academy. One particular program, many of the programs attended by me, fortunately, was when Dr. Mohan Gopal was the director of the academy. One particular program is known as JEEP, J-E-E-P, Judicial Excellence Enhancement Program, conducted in 2 phases, JEEP 1 and JEEP 2, in consecutive 2 years, 15 days each at a stretch. It was a marvelous program. In fact, immensely worth and useful for the judges. You take it from me, this is not for praising him. This is the ground reality. If I will be failing my duty, if I am not disclosing it to you, that I have been, in my estimation, I have been benefited to a great extent by the particular program itself. It divided into 3 branches. One is court management, other is judgment writing, and other is regarding legislation. And the participants were given the option to elect any program. I opted judgment writing. Fantastic program. This is, I'd be ungrateful if I did not mention it. So now coming to Constitution, because I am cutting it short, only some few words to give the time more to our speaker. Constitution is nothing but, to simply say the Constitution is the division, distribution, and management of state power. This is simply what is Constitution. In the words of Raymond Mollett, the formation of a constitutional government is a significant mark of distrust by the human beings of the human nature. Very interesting. Human beings themselves distrust human nature. That is why constitutional government is for. Constitution is for. It signalizes a profound concept born of experience that if a person is vested with authority, he should be controlled. He should be restrained by some more potent authority than his own conviction, his own discretion. That is why the constitution is so. Now coming to the Indian context, our constitution controlled governance, limited governance with judicial review is the essence of Indian constitution. We know judicial governance, controlled governance, limited governance with judicial review forms the essence of the Indian constitution. Means if an act of any governmental agency, when it transgresses a constitution, a competent court with authority can invalidate the action of the government, including the legislature. When it transgresses the constitution, it is violating the constitution. Mainly, Indian constitution involves three elements. Three elements mainly. First thing, the constitution. Constitution sets up and limits different organs of the state. One thing. The constitution sets up and limits the different organs of the state. Second element, constitution functions as a supreme law by which the different organs of the state, the conduct of the different organs of the state are to be judged, Then third, a sanction by which, that is what I said just earlier, a sanction by which the violation of the supreme law by any of the organs can be prevented, restrained, or even annulled. This is what is in the modern context is known as judicial review. Now, coming back to the Constituent Assembly, it met for the first time in 9th December 1946, and it elected, after 8 months, they constituted the drafting committee, which consisted of 7 members from my memory, with Dr. Ambedkar, Alladi Krishnaswamy Iyer, Gopalasamy Iyengar, Mittal, Munshi, I think Kaitan, and one more person is there. 7 persons, one died and substituted by, I think Krishnamacharya substituted him, and one person resigned of ill health. I think it is Mittal, is substituted by Madhav Rao. I am not mentioning, it is not for mentioning the names of the drafting committee. I am mentioning this because I will be failing again my duty if I am doing in the history, if I don't mention 2 persons. They are not the member. One person is Mr. B.N. Rao, Benegal Narasimha Rao, who was the constitutional advisor to the Constituent Assembly. Second, S.N. Mukherjee, Surendranath Mukherjee, he was the Joint Secretary of the Constituent Assembly. As regards B.N. Rao, the person of immense capabilities. In fact, he prepared the first draft of the Constitution, on which the discussion went on, with marginal notes containing reference to the constitutions of all the countries. He traveled all over the world and conducted discussions with the constitutional experts of different countries. And it is said that the due process clause was not included in the constitution, draft constitution, on the basis of his discussions with the experts of the different countries. The encomiums and the tribute paid by Dr. Ambedkar and also by Dr. Rajendra Prasad at the time of the conclusion of the making of the constitution themselves reveal the potential of this person, B.N. Rao. And Justice Frankfurter commented about B.N. Rao. He said, if I were asked by the President of America to name a person to be appointed as the judge of the American Supreme Court, who is having knowledge of history and working of American Constitution, I would prefer B.N. Rao first. That was the potential of a person, often not remembered. Second person comes Surendranath Chatterjee, S.N. Mukherjee. He was a person who was meticulously drafted the different provisions of the Constitution, which was finally adopted. Now the Constitution, the wordings of the Constitution which we read, were meticulously drafted. The provisions were by this S.N. Mukherjee. He was also, Dr. Rajendra Prasad commented about him in the conclusion of the making of the constitution, that without Mukherjee, we would have taken years more to complete a constitution. This was that person. So we have to remember, this is a particular moment I mentioned about them. I am coming back to constitutionalism. With my limited knowledge, constitutionalism, what is constitutionalism? I would define with my limited knowledge, I would define it as an effort to establish the supremacy of law. This is a simple thing. An effort to establish supremacy of law. How the judges are connected with it, that is what often thought of. Is it the judges who are connected with it? Every citizen is connected with it. When you have to observe the values, when you are observing the values of the constitution, you are establishing the supremacy of law. When a judge is saying a case, he has to, the action of a judge should reflect that he is establishing the supremacy of law. Otherwise, he will be a failure. This is not said by me, by the great Justice Krishna Iyer. He was quoting Justice Krishna Iyer in Rethil municipality's case. When saying about Rethil municipality case, only one sentence, I would, opening sentence I remember, by the opening sentence, judge entered the crux of the matter. Rethil municipality case is a case challenged by the municipality against the direction to construct sanitation facilities. It reached up to the Supreme Court. A simple case. But Justice Krishna Iyer entered by the very first sentence, by my memory. This is, quote, if I am mistaken, I may be excused. The procedural rules, as this appeal proves, which infuse life into substantive right, which activate them to make them effective. Beautiful. How beautiful it is. Judge entered into the crux of the matter, and it opened the gate of public interest litigations in India. This is an instance of constitutionalism. And in the very judgment, the first paragraph, Lordship quoted, I think, Professor Sykes. Professor Sykes, he quoted a portion. It is reported in action, not actual quoting. A portion sentence is that the system may crumble under the burden of its own insensitivity. This is the term used. The system may crumble under the burden of its own insensitivity. If you are not sensitive, if you are not agile to the values of the constitution. So normally said trial courts, what is the application of constitution there? They have to reflect our action should reflect that we are upholding the values of the constitution. We are upholding the values of the society, the values which the society want to protect. It is the duty of the judge. When the judge fails in such a duty, he is a failure. He will become a burden. And he is insensitive, and it will result in the crumbling down of the system, the entire system. So this is an effort. In fact, this present discourse, without mentioning Justice Krishna Iyer, any academic discourse regarding philosophy, law, legal philosophy would not be complete, even would not be worth. Accidentally, I mentioned about the municipality's case. This is the value. This is the value which Justice Krishna Iyer promoted through several judgments are there. Ever so many in words he described it. So this is what the society expects from every city, including a teacher's constitution. In one case, in my memory, Justice Krishna Iyer referred about inequality, classification, unequal classification. The judge observed that the court must hold the executive by the lauding strings of egalitarian constitutionalism. Egalitarian constitutionalism. The wording is that the court must hold the executive with the law by the loading strings of egalitarian constitution. This is also very for Justice Krishna Iyer. So this is a person we have with us, an eloquent speaker of deep knowledge will follow. So I'm cutting short my words. In the beginning, I said that I am trying to plow the field for the seeds to grow, but I think I could make only a mess. I only stirred the points. In fact, I will conclude remembering the words of Lord Denning in the famous speech of Rahmatullah versus Nizam of Hyderabad. Only one sentence, small sentence, Denning quoted. I stirred these points which wiser heads in time may settle. So here, I only stirred some points for the wiser head, Dr. Mohan Gopal, to settle, and he will come and settle it. And I wish this program, this series, lecture series, all success. And it is in fact an instance of a constitutionalism, because we are promoting values of constitutionalism among the judicial officers and members of the legal fraternity. So I wish all success. And with your permission, I formally inaugurate this lecture series on constitutionalism. Thank you. Thank you very much.
Thank you, sir, for those enlightening words. May I now invite Professor Dr. G. Mohan Gopal, sir, to deliver the address on constitutional vision of justice.
Thank you very much. Most respected Dr. B. Kalam Pasha, Principal District Judge, respected Mrs. Anupama, Honorable Judge, Secretary of the District Legal Services Authority, other honorable judges who are part of the audience, and other colleagues from the legal community who are in the audience. Let me begin by congratulating the Honorable Principal District Judge, Dr. B. Kalam Pasha, for this important initiative in organizing a series of reflections on our Constitution. And it is indeed most timely, because we just on the 27th of November, that's 19 days ago, the Honorable Supreme Court of India, in a judgment, said, and I'm quoting, "We must emphasize the role of the district judiciary, which provides the first point of interface to the citizen." And the context was the role of defending constitutional rights. The Supreme Court says, we want to emphasize the role of the district judiciary, which provides the first point of interface to the citizen. It says, our district judiciary is wrongly referred to as the subordinate judiciary. It may be subordinate in hierarchy, but it is not subordinate in terms of its importance in the lives of citizens, or in terms of the duty to render justice to them. These are words 19 days ago from the Supreme Court of India, in the context of, this is in the case involving Arnab Goswami, Arnab Manoranjan Goswami is the name of the case. It is a judgment by Justice D.Y. Chandrachud. And he's telling us something that we've been emphasizing for many years at the National Judicial Academy, where we never use the word subordinate judiciary. We always refer to district judiciary. There are subordinate courts, but the judiciary is not subordinate. The Constitution refers to subordinate courts because of the hierarchy of the jurisdiction of courts. But as Justice Chandrachud has correctly said, our district judiciary is not subordinate in terms of importance in the lives of citizens, or in terms of the duty to render justice to them. And so we have a very auspicious environment in which to begin, and which underlines the words, that the very eloquent, erudite words that we just heard from the Honorable District Judge, Principal District Judge, Dr. B. Kalam Pasha, from whom I have had the opportunity to learn a lot. We've had many interactions, many discussions, and he has taught me a lot. So I consider him as one of my teachers, as I do many of the judges who came to the National Judicial Academy and were kind enough to enlighten me about this system that is central to our republic and our constitution and our country, and that we have to protect and we have to strengthen at all costs. So therefore, we are starting with a mandate from the Supreme Court of India, 19-day-old reminder of the importance of the subordinate courts in the duty to render justice to them. This also reinforces Article 39A of the Constitution, from which the Legal Services Authority derives its work and its mandate. And therefore, the legal services authorities all over the country are actually directly mandated by the, as we know, by the Constitution of India. And Article 39 says, the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity. Promote justice is the mandate of the legal system, not just the judicial system. That includes the bar, it includes the administrative officials who are involved in the legal system, police and other administrative officials. It includes litigants who come and use the legal system, and also includes law students and the legal academy, legal academics. We are all part of the legal system. And Article 39A of the Constitution says that that the state shall secure that the operation of the legal system promotes justice. So promote justice is the two-word mandate of the legal system. So when you look at courts, and as one of the aspects I emphasized a lot during my time at the National Judicial Academy, I still interact a lot with judicial academies all across the country, is for us to understand the difference between court and judge. Judge is the presiding officer of a court, but the court if a court has to function, all the people that I named earlier have to cooperate and contribute to its functioning if it has to function effectively. And so our focus is on getting this institution called the court to function effectively. It is the court that delivers justice, not just the judge. The judge is the instrument of the court. The lawyer is the instrument of the court. The parties are instruments of the court. Witnesses are instruments of the court. Executive branch are also instruments of the court. And when we all come together, what we do must be that the court must secure and promote justice. And therefore, it is very important for all of us to understand very clearly what we mean by the idea of justice. Now, let me say at the very beginning that, as all know, the idea of justice is perhaps the most important idea for humanity and for society. Many revolutions have been fought, many governments have been overthrown, many people have been prepared to die for the idea of justice. It is one of the most important ideas which animates all human beings. And recently, someone was suggesting that to understand justice is a very sophisticated facility which human beings have to develop through education, and I beg to disagree. If you take a piece of chocolate and you divide it into two unequal halves and give it to two children aged 3 or 4 years of age, one of them who gets the unequal half is going to protest because somehow that person feels that something wrong has been done. So the sense that human beings should not be subjected to wrong conduct by others, that we are entitled to right conduct, is very, very important. I often think of the words in the Bible of Jesus Christ, who says, "Do unto others as you would have them do unto you." That is a standard which is the basis of the need to formulate an idea of justice. Jesus is saying that we must treat others as they would treat, as we want them to treat us. But what is not so much recognized is that Jesus is also saying that each one of us must have, we must have a standard about what is acceptable behavior towards us. How should people behave towards us? And Jesus is saying that once that is clear in our mind, then we must ensure that we behave to others in that manner. This need to have a framework about how I must be treated so that I can be happy, that I will not be sad, I will not be subjected to unhappiness or suffering. What can human beings do to ensure that that each of us is able to pursue happiness? The Declaration of Independence of the American Constitution talks about life, liberty, and the pursuit of happiness. And so how can we pursue happiness unless human beings are committed to making each other happy? So we must first have a standard about what is required for us to be happy. And then we must also be sensitive to what is required to make other human beings happy. And we must comply with that standard, which must be at the minimum the standard that we expect from others. It certainly cannot be less than that. It is to ensure that human conduct is right and not wrong that we have a system of law and justice. The only issue that a court is concerned with is human conduct right or wrong? There is no other issue. If, for example, a branch of a tree falls on my head, I cannot come to a court and sue the tree. But if there is a human intervention, that someone was negligent in not cutting the branch of the tree properly, negligent in looking after the need to keep the passage or the road through which I walk safe, then I can go to a court. Because the only reason I can go to a court is to determine whether or not human conduct is right or wrong. And therefore, the sense of right or wrong human conduct is at the heart of the constitution of human society, and also at the heart of the judicial system, which to me is ultimately just a system to ensure that human conduct is maintained as much as possible as right conduct. And we find effective ways to prevent wrong conduct. We are really not concerned about the wrong conduct that has already happened, except to the extent that through the way we deal with human conduct that has already happened, we can prevent wrong conduct from happening in the future. Which is why the only jurisdiction of courts is, as a cause of action, is past conduct. The directions can be given towards future conduct, but the cause of action must always be about a past conduct having violated a standard that was expected and established in the law, which was violated by someone, and so we go to a court. Therefore, what I'd like to say at the very beginning as an outset is that at the center of our work in the legal system is the concern about what is the right way in which human beings must behave and we must treat each other. And this is, as I said, a very central concern of society, because nothing else in society can work unless this fundamental requirement that human beings behave in the right way to each other is protected and preserved. Now, the question, of course, is how do you decide what is right and wrong conduct? And that's where the idea of justice comes in. As you know, the root of the word justice is J-U-S. J-U-S is pronounced, as you know, as use. J-U-S, use. Use means the right value. Use means the quality of rightness. That is why we sometimes say to judges, your decision is just, because it is imbued with use, rightness. We also say, just give me half a cup of coffee. Why do we say the same word which we use to describe a judgment as just? We say, when we want a cup of coffee, and say, just give me half a cup of coffee. What we're saying is half a cup, not a full cup, will be the right value for me. The right value for me is half a cup. And therefore, the word use is the quality of rightness, is what gives something rightness. Half a cup will be right for me. 1 cup will be too much. Quarter cup will be too little. Half a cup will be right. Just right means imbued with rightness. Similarly, in other areas, when we use the word JUS, we refer to the idea of rightness. And therefore, the word justice comes comes at the root from this idea of rightness. And justice is the prevalence of rightness. Justice is a statement of the content of rightness. The prevalence of rightness is referred to as the prevalence of justice. But justice itself refers to the content of rightness. What is it that makes something right? And so the content of justice must be very specific in terms of what is the what is it, what are the norms, what are the benchmarks by which conduct will be right and will be wrong. And this is where there are very big disagreements between cultures, communities, nations, and age groups and different professional groups. And this is what the court system exists for, you to resolve these disagreements about what is right conduct and what is wrong conduct. And we have laws which define what is wrong conduct, and we have the rest of what is not defined as wrong conduct is what we consider from the legal perspective right conduct. Although it may be illegal, there may be social or moral expectations of right conduct, and that's where we make the distinction between law and morality, that kind of right conduct. So the difference between law and morality is not that morality deals with right conduct and law does not deal with right conduct. They both deal with right conduct, but we take those aspects of right conduct which are most important for the survival of our society, and we elevate them to the status of law, and we attach rights and liabilities to expect that those standards of conduct will be observed, and consequences if they are not observed. And so law is a statement of our norms of conduct that we expect. So if you take the word justice, we can also, simple way to remember it, though it's not, it is maybe not etymologically 100% accurate, but a simple way to remember it, that jus refers to values and stis refers to what stands. That's like stick, it's the same root as stis. So jus stis or justice means those values that are eternal, that stand forever, not temporary. So we can say that justice represents eternal values. What we consider, what each person or each group of people considers to be eternal values that will never change. If it changes, then that group will collapse. So, for example, if when the Sikhs greet each other, they say Sat Shri Akal. Sat Shri Akal. Akal means eternal. Satya is God. Satya, Shri hai and Akal hai, which means truth is God and truth is eternal. So for the Sikh community, the eternal value is truth, Satya. And if that is lost, then the Sikh community cannot exist anymore. It's a wonderful, extraordinary greeting. Similarly, when Muslims greet each other and they say Salam Alaikum, right? And they reply by saying Wa Alaikum Assalam, they are giving most importance to peace. They are saying, may you have peace. So to have peace, you must have truth. You must have right conduct. So if peace does not prevail, then something will be lost from the heart of Islam, because it's a religion committed to the idea of peace and how to achieve and ensure peace. It is a religion of peace. The Sikhism is a religion of truth. They're all interrelated and complementary. There is no conflict between any of these doctrines. But ultimately, whether it's a family, a group of friends, or a nation, or a religion, they are brought together by a shared sense of values about what is right conduct and what is wrong conduct. And therefore, a nation is nothing more than a set of eternal values. And if we are not practicing those values and we are not committed to it, the nation will not survive. And therefore, a common understanding of justice as a set of eternal values that constitutes, that's why we call it the Constitution. Constitution is actually a set of values that constitute a community of people. India is not just a piece of land. It is that, but it is more. India is not just a set of buildings or power or poverty. India is a community of people. And there is a wonderful judgment, again, very recent, February 2020, by Justice Ravindra Bhatt in the of the Supreme Court judgment in a case called Prithviraj Chauhan versus Union of India, a recent judgment, February 2020, where he says, and I'm quoting him, the Constitution of India is described variously as a charter of governance of the Republic, as a delineation of the powers of the state in its various manifestations vis-a-vis inalienable liberties, and a document delimiting the rights and responsibilities of the Union and its constituent states. He says, yes, that's correct. But he says, it is more. It is also a pact, an agreement between people about the relationships that they guarantee to each other, apart from the guarantee of liberties vis-a-vis the state, in what was once a society riven, or what was a society riven along caste and sectarian divisions. This is why the preambular assurance is that the Republic would be one which guarantees to its people liberty, dignity, equality of status and opportunity and fraternity. It is this idea of India, a promise of oneness of and for all people, regardless of caste, gender, place of birth, religion, and other divisions, that Part 3 articulates in 4 salient provisions, Articles 15, 17, 23, and 24, and then he goes on. But let's reflect a moment on, this is a judgment worth reading. He talks about the Constitution in a very philosophical and very profound way. It is one of the most important judgments on these fundamental ideas of justice and law that I have read in a long time, Justice Ravindra Bhatt in Prithviraj Chauhan. He says that the Constitution of India is a pact, is an agreement between people about the relationship that they guarantee to each other. It's a pact about a standard of conduct that we will maintain to each other. So the law and the courts are mechanisms to ensure that that pact is observed, that those standards of conduct are maintained. So the first point I told you is that justice literally means a standard of human conduct, a set of values about what conduct is right. So it's a standard of right conduct. That is the meaning of the word justice, standard of right conduct. And then I said, what is the content of that standard? Given that we all have very different ideas about what is right or wrong conduct. And then Justice Ravindra Bhatt, through the Supreme Court of India, just a few days ago, reminds us that the Constitution is a guarantee, a pact, a guarantee of how, a guarantee of people to each other, about how what the standards are of their mutual relationships, about how they will treat each other. So that makes, when we say, when we understand the Constitution in this manner, we understand that the Constitution is a guarantee about how other people will treat me in India and how the state will treat me in India. And so then it becomes very important to understand justice, because justice is that standard of conduct which we have to follow in order to give content and meaning to the Constitution. Now, given that many people have many different ideas of justice, and we cannot find a consistent, and I can tell you this because I've been studying this for many, many years, you will not be able to find a clear, consistent, and accepted definition of justice in academic texts, in philosophical writings, in academic writings or literature, or in judgments. So if the Constitution is a guarantee, according to the Supreme Court of India, but how people will treat each other in their mutual relationships, and justice is the standard of conduct governing human relationship. That's what it means. Justice, eternal values that will govern human conduct to each other. Then we cannot find a consistent definition of a standard of conduct in academic literature or any other source. And there is huge difference and conflict and diversity about the understanding of the content of justice. then we have no option except, and we have a highest obligation and no option except to find the content of the idea of justice, that standard of conduct that we are expected to and required to observe to each other in the Constitution of India. And that's what we will do in the next few minutes, and then we can have a discussion. What is the constitutional expectation or constitutional mandate, or the constitutional obligation on how we treat each other? Because justice is a standard on how we treat each other. Now, I'd like to say one more brief thing and then get into the constitutional vision of justice. And that is that there is the reason why we cannot find the kind of answer to the idea of justice that we are looking for satisfactorily in Western academic literature. Sometimes they argue that justice is everyone getting their due. They say that justice is a correct distribution of resources between people. And some people say that it is observing procedures correctly and obeying the law and respecting the law, and that is justice. Some people say it is utilitarian, that justice is something that through which we can achieve ends set by legislatures or by the state. Some people say that it is a relative concept, that you have to look at what everybody gets and make sure that there is some equality and some rationality about how different people get. So it's basically, justice is usually seen in Western countries as a standard about how the powerful people treat the powerless people. Rather than in this Indian constitutional sense that Justice Ravindra Bhatt very, very insightfully describes. It is an agreement, the state is not involved, it is an agreement between people about the relationships that they guarantee to each other. These are the exact words of the Supreme Court in the judgment I was referring to. It is a pact between the people about the relationships that they guarantee to each other. And when they do not respect that pact, they are actually betraying the Constitution and breaching the Constitution. And to prevent that, Justice Chandrachud has said in a 19-day-old judgment that the district judiciary is at the front line of ensuring that the people of India treat each other in the manner that they're required to teach each other. They've guaranteed each other in the Constitution. Now, this is especially important for us because we must remember that in some countries, like in Western countries, where a lot of these writings come from Rawls and from Dworkin and Nozick and Aristotle and Plato and all these people, that at the understratum, at the bottom of these Western societies is a common agreement of a ethical framework that comes from their religion, Christianity. All religions have an fundamental ethical framework. Christianity has a fundamental ethical framework. And these are countries from whose academic literature we are reading, where everybody agrees about the Christian ethic. And then their challenge of justice is a second generation challenge. Given that we accept the Christian ethic of right conduct of people towards each other, then can we take it to the next generation and get more specific about how do we distribute resources to each other? How do we achieve our ends, utilitarianism? How do we use justice as a corrective idea to correct people who are deviating from this Christian ethic? How do we use justice as an idea to reform and bring society and institutions back on track? And so that is the context in which they are discussing the theories of justice. But our situation is different. We are only 70 years old as a republic. We have a very large diversity of religions. I don't believe that there is any conflict between the fundamentals of these religions. In Kerala, Narayana Guru has repeatedly pointed out that there is no contradiction between the conflict, which is what he means by one religion, that there is no conflict between the fundamental values of religions, and I accept that. But having said that, there are very important differences. And so we don't have that first foundation that Western countries have, that they have a Christian ethic on which they're building the idea of justice. We don't have that. Therefore, we need, and I'll come back to this, we need to find a common ethic, a common value on the basis of which we can build our institutional ideas of justice, which include freedom, equality, liberty, fraternity, fundamental rights. These are ideas in the Constitution, but they all have to stand on a foundation of an ethic that is common to all of us and accepted by all of us. And I will end with that discussion, but I want to come back to that. I'm simply saying that we cannot simply borrow what Western countries talk about justice, not because they are different. We're all human beings. We all have the same impulses. But they are starting from, most of this Western writing is starting from, that we use and borrow in legal literature, starting from the foundation of a shared commitment to Christian ethics. And we don't have that. And therefore, we need to find a shared commitment to Indian ethics. What is that? That everyone will accept and is common to all of that. And that must be the foundational idea on which we build the institutional ideas of justice. And I will, as I said, come back to this. This is just to make a brief point. Now I come to the second. This is the first point I'm making. I'm only making 3 points today. The first point I'm making, which I finished, is to argue that justice is a standard of human conduct. It is not the result of observing the standard, namely people get the right distribution, right utility, retribution, satisfaction, whatever. Those are the outcomes of following justice. But justice is a standard of human conduct. And it is usually standards that are long-lasting, not temporary standards. Long-lasting, the highest level standards. So if you take the Christian ethic, it's about love, it's about forgiveness, it's about compassion, it's about brotherhood. If you take Islam, it is about brotherhood and mutual love and fraternity at the foundation of Islam, and so on. So we have to look at the justice as a foundational ethical standard of human conduct. That's my first point. The second point I'm trying to make, I'm making is, at the beginning I said that we cannot find this standard, this foundational standard in our society or in our personal background, because that would create enormous injustice, arbitrariness, subjectivity, which is against the rule of law and which is against the idea of justice. Predictability and certainty about the standard of conduct that will be followed in applying justice is a very important part, is itself a standard of conduct. That is the content of justice for us, that it must be consistent, it must be applied equally regardless of caste, gender, race, religion, region of the person to whom the standard is to be applied. So we cannot find that standard in any place except in the Constitution of India. And therefore we must locate our idea of justice in the Constitution of India. And that's my second point. And I will now briefly talk about what is the content of that idea of justice. This is just to share some thoughts. Nothing I say is to advocate a point of view or to propagate a point of view. I'm simply setting out a set of views so that you can think more about it. You can completely disagree. You can throw away what I say. But if you think about the question, what is justice, and what are the courts expected to do in upholding justice, then my mission would be accomplished. I would just, as an academic, I just like to encourage people to think and to question. Now, when we come to the constitutional vision of justice, let us note from our previous discussion that what we are searching for is a set of eternal values in the Constitution, a set of eternal values in the Constitution, because that we know that justice is a set of eternal values that should be the standard of conduct governing society. And we know the Supreme Court has told us that that the Constitution is a guarantee of the people to each other about the standards that they will apply in their relationship to each other. Where do we find the standard of conduct? We find that standard, as all of you know, most importantly, in the preamble to the Constitution of India, a summary of those standards. A preamble, Professor Upendra Bakshi once beautifully said that the preamble to the Constitution of India, the preamble is the Constitution of India, the rest is only a footnote. That was his very eloquent way of telling us that the preamble is very, very vital to understand the Constitution. And it's perhaps the most important part of the Constitution that we need to understand. I consider the preamble the blueprint of the Constitution, and the entire Constitution structure is in the preamble. The preamble has only 85 words, but it contains the full blueprint of the ethical content of the Constitution. And if you look at the preamble, I would argue that we can find 9 values, which are eternal values, which constitute the Republic of India. Without these 9 values, there will be no Republic of India. And those eternal values is what gives content to our idea of justice. And that is why the first objective in the preamble is, we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to its citizens, to all its citizens, the first objective of the republic is to secure justice, social, economic, and political. The first objective. The reference here is not to justice administered by courts. It has nothing to do with courts. It is not to refer to the Indian state. The people of India have formed this republic to secure to ourselves justice, social, economic, and political. And if it is not about courts, it is not about the state, what is it about? Here, justice simply means a standard of conduct. Justice, social, economic, and political means to secure to ourselves a society in which social, economic, and political relationships will be governed by eternal values set out in this Constitution. And that is why the word justice is used. So you can replace the word justice and say, to secure to all its citizens social, economic, and political relationships based on eternal values of conduct set out in this Constitution. That's what the word justice means there. Now, justice is therefore the objective. Then we can say that there are 9 values which give content to the idea of justice, which are specific standards of conduct. The first of these values is, in my mind, liberty. Liberty, individual liberty, most important value. The second most important value in the preamble is equality, as Justice Ravindra Bhatt has said. The third most important value is fraternity. So this is already, liberty means freedom from restraints imposed on me by other human beings. If a tree crashes down the road on which I'm traveling, I won't say I've lost my liberty. But if that tree is cut down and put in my way to block me by a human being, then I'll say I've lost my liberty. Because my liberty and my freedom are constrained or taken away by other human beings. And therefore, the value about how, as Justice Ravindra Bhatt has said, how relationship with each other shall respect the liberty, the freedom of every individual. Equality is about how we treat each other. We can talk more in detail about what is equality, but it's ultimately about how we treat everybody based with the same respect and the same value. Justice Bhatt's judgment talks about that. We treat each other without increasing or decreasing the value we give to people based on their caste, religion, gender, rank, position, status, wealth, language, religion. We give everyone the same value. That's what we mean by equality. Fraternity, that we shall be brothers and sisters to each other in the sense of friendship, in the sense of being there for each other, supporting each other, not attacking each other, not conflicting with each other. The fourth value is dignity in the preamble, individual dignity. Now, These four values, liberty, equality, fraternity, and dignity, are about how we treat each other as citizens and how the state treats us. I expect that the state, the police station, or the court will respect my dignity, will not abuse me. I've sat in courts in other countries, especially in Western countries, where even the poorest and most most criminal, the most vile criminal is addressed with respect by the judge and the court officials. They call them sir, because everyone is entitled to be treated with respect and dignity. So these four values are values about how we treat each other. Then we have, in addition, we have four values about the ideology of our society, the political ideology of our society, which are necessary for the existence of these four ethical values. And those are democracy. Democracy, the simple word means kratos, K-R-A-T-O-S. Kratos means power. Is in the hands of demos, D-E-M-O-S, demos. Demos means common people. So democracy means a political system in which power is held by common people. So in the Objectives Resolution of the Constituent Assembly, it was said that all power and authority in independent India shall be derived from the people. So that is democracy. Not simply voting, that's necessary, but not sufficient to vote. We must also have a system where all power is devolved down to as a matter of ideological commitment in order to ensure equality, liberty, fraternity, and dignity. You cannot do that without a political system called democracy. You cannot do that, because if it's not a democracy, there will be no equality, there will be no liberty. Rulers will tell you what your freedom is and decide what your status is. So democracy is essential as a political value that we must respect if we must uphold the way in which we treat each other. Democracy is also a culture. It's a way of treating each other, respecting that power must be held by everyone, not just concentrated in a few more meritorious, more deserving, or by birth or otherwise class of people. The second institutional value in the preamble is republicanism, where again, republic, like we say judicata, the word republic, as you know, means the res, the thing, the state, the government belongs to the public, not to an elite. That is what we mean by republic. The rest belongs to the public. It's just like democracy. And we have envisaged a sovereign republic. We have also envisaged sovereignty as part of republicanism, where the sovereignty of the republic will rest not only in all of us as a collective nation, but also in each of us. That in our democratic society, there should be none superior to us. So sovereignty, I would argue, exists both at the individual level and at the level of the institution and the state. So we have republicanism, and we have sovereignty, and we have democracy. Then we go to secularism, and the Hindi translation or Hindi text of the original Constitution of India, still the Hindi text of the Constitution of India, has what I believe is the most accurate translation of the word secularism, which has become very confused through political discourse and public discourse in this country. The Hindi word is Panth Nirapeksh. Panth means path. What path you choose. It's not even religion. What spiritual path you choose. Nirapeksh, without reference to your panth. The state, the government of India, the rulers of India should never take any decision or undertake any official action keeping in mind the panth, the path, the religious or spiritual path of the people that they're dealing with. All their decisions must be panth nirapeksh. That's what we mean by secularism. Not sarva dharma samabhava, in my view. That was introduced through political discussion, not originally in the constitution, still not in the constitution, where it is like having all religions as equally important. Because we have diversity of religions, the idea of the constitution is that state decisions, official decisions, shall be panth nirapeksh, without regard to the religion of the people in front of you. And lastly, we come to the ninth value, and that ninth value is socialism. And by socialism, we don't mean European socialism, we don't mean Marxist socialism. We mean the socialism that has emerged from our freedom movement, and that is set out in the 17 directive principles of state policy in our constitution, and in these ideas of liberty, equality, fraternity, and dignity. It is our constitutional socialism that we are talking about, where we have fraternity, we look out for each other. We have brotherhood and we have love, and we stand together regardless of our differences and our background. It's very, very important because we have differences. Some people say that we cannot be equal because we have differences. Actually, reason to have equality is that there are differences. If there were no differences, we do not need the concept of equality. I don't need to be equal to myself because there is no difference between me and me. But when I come to another person, I need to talk about equality because we are different. So when we are different, we should learn to discount or ignore the value of those differences and say, in spite of the differences, we value each other the same way. So equality is a system or a method of valuing each other because we have differences. And so socialism is very much part of equality, fraternity, dignity, liberty. And when we have these 9 values, which I call Navaratna, 9 values, then the outcome is justice. Because this is the content of the idea of justice that is in our constitution. I have realized after several years of working on the idea of justice that left to itself as a mere word, justice is empty in its content. The word is empty in its content. And like happiness, like sadness, many of these very important words are inherently empty. Even love. Lots of hateful things are done in the name of love. And people who do it still say, no, I'm being loving, but that's not the content of the word that we have in mind. So like other important words, these are essentially empty words. And we must fill or pour content into this word and give it content. And that is when justice will have content. So we must deliberately and consciously understand justice only in terms of these 9 values that are in the Constitution. And we have to say that promoting human relationships, to take the words of the Supreme Court, or human conduct consistent with these 9 values is what we are required to do under Article 39A. That all our relationships, all our decisions and interventions must promote these values. This is what the constitutional vision of justice is and demands for us to do. Now, I'll just say one more brief explanation of the constitutional vision of justice. There are some people, and Ambedkar himself rejected this argument, some people who believe that these ideas of equality, liberty, fraternity, and so on have been borrowed by us from Ireland and United States and so on and so forth, other constitutions, and are really not our own. And there are people who argue that therefore we should not accept it because they're not our values. And I totally disagree with that, because I believe that the freedom movement did not abruptly come to an end in 1949 when the Constituent Assembly was formed on December 9th, or in 1947 on August 15th when we became independent. Even today, the freedom movement of our country is what guides us. It is the spring. It is the Gangotri from which the entire constitutionalism of India emerges. And in that sense, we have to understand Indian constitutionalism as an ethical project, as project of ethics, of how human beings, as Justice Bhatt said in the judgment I referred to, about how a project about how human beings must treat each other. That is constitutionalism for us. Not simply about limiting power. If we limit all the power and we don't follow these values of socialism, secularism, democracy, and all these other values, then it is not constitutionalism for us. And therefore, we must understand that these were not borrowed ideas. They came from our freedom movement. And I will very briefly say that we can locate all of these Navaratna, these 9 ideas, in four concepts that were central to our freedom movement. And those 4 concepts are very, very central to our freedom movement. First is the idea of Swaraj, for the country and for me as an individual. Gandhiji described Swaraj as a condition in which a human being is able to control his life and his destiny. So we envisaged a country in a society where the most disadvantaged person, the most marginalized and excluded person would be able to, once India is free, control his own life and destiny. And so would all of us as a community of Indians. So Swaraj is the central idea. It predated Gandhi. It is a central idea that animated our freedom movement. And Swaraj has not ended with, with the adoption of our constitution. And Swaraj is our way of expressing what in Western constitutions describe as liberty or freedom. Swaraj is a similar idea with a difference, because there are 3 conditions to Swaraj. 3 conditions to Swaraj, which are not there in the original idea, in these other ideas which emerged in other countries of liberty and freedom necessarily. Although I think they're also there, but not understood in the same way as we understand. What are these 3 ideas? The first of these 3 ideas to which by which my Swaraj must be guided is Satya, truth. Yes, I have Swaraj, but the Swaraj must be based on truth, self-realized truth, not truth dictated to me, by methods of rationality, methods of thought and rigor and debate and analysis, like a judicial process, is a method of finding the truth, because truth is very important to all systems. So through accepted rigorous methods, ensuring that my Swaraj is based on truth, stands on the foundation of truth, is the first limitation. The second limitation of Swaraj is ahimsa. That my Swaraj must be used by me subject to non-violence, ahimsa. It was very central. Dr. Ambedkar acknowledged that non-violence is very, very important to the people of India, that therefore he opposed the death penalty. So my Swaraj must be subject to ahimsa. Third, my Swaraj must be subject to the principle of Antyodaya. Antyodaya means Antimka Uday, the rise of the last and the least. Antimka Uday, the rise of the last and the least. So the first claim on my freedom, my Swaraj, my liberty, is of the last and the least, of the person who is at the bottom of society. It is him I must, or her, that I must serve using my Swaraj first. And lastly, Sarvodaya, Sarvaka Udaya. So everyone must benefit from my Swaraj. So individual freedom, liberty, equality, fraternity, which is all part of Swaraj, based on truth, Satya, based on ahimsa, non-violence, based on Antyodaya, the interests of the last and the least, and based on Sarvodaya, everyone's welfare, no one to be excluded. This is the framework of values of the freedom movement from which the constitutional vision of justice has emerged in the preamble to the Constitution using legal language, because the Constitution is a legal document. We can't put these words into a constitution and apply them. But when we apply them, we must be guided by this vision of justice of the Constitution based on our freedom movement. And all these 5 concepts, Swaraj, Satya, Ahimsa, Antyodaya, and Sarvodaya, all these 5 concepts can be reduced, and this is where I will end, as I said I would, in one common ethic for all Indians, from which the freedom movement comes, from which the Constitution of India comes, and which is the foundation of the Constitution. And that is the idea of compassion. The idea of compassion. The idea of anukampa. The idea of karuna. Why do I say that this is the equivalent for us of the Christian ethic in Western countries? Because compassion is an idea that is central, not just important, central to all the religious traditions of our country and all the cultures of our country. For Christianity, obviously, compassion is very important. What do Muslims pray 5 times a day? They pray to God, the merciful and the compassionate and the beneficent. They plead for compassion and mercy. It's very central to Islam. It is very central to Jainism. It is very central to Buddhism. It is very central to Hinduism. Narayana Guru, for example, composed Anukampa Dashakam and said, Oru Pida Erimbinum Varitharida Ennulla Anukampayum. Oru Pida Erimbinum Varitharida Ennulla Anukampayum Karunakara Nalgugulil Nin Tirume Vittagalada Chintayum. So Anukampa is part of all our traditions, very central to us. And it is this idea of Anukampa. We had Anukampa towards the British, towards the people who colonized and exploited us. Not only British, but other tyrants that ruled us in our society, in our country for centuries. We have compassion towards them. I read in another Supreme Court judgment how there was a caste riot between scheduled castes and some Thakurs in the north of India. And in that riot, some Thakurs were injured in the riot. And the scheduled caste people stopped all the riots, put down their sticks or whatever they had, and rushed to treat and help and take to to help the Thakurs who were injured. That is Anukampa. So it is at the root of it is our constitution is based on Anukampa. Anukampa is an idea that comes from our tribal people, from our Dalit people. It is very fundamental to tribal peoples all over the world. And therefore, when I talk to non-lawyers, I describe the Constitution of India as a book of compassion. And constitutionalism as the practice of compassion. Now, what does compassion mean? Compassion doesn't mean that you acquit everybody. You don't punish everybody. No. I have been talking to, as some of you know, I've been talking to some of the probation officers. And in one of the cases I've been talking to them is a judgment by Justice Krishna Iyer from the Supreme Court called Ved Prakash, 1980 judgment, where he demonstrates compassion. He talks about how sentencing the mission of sentencing must be to humanize the wrongdoer. He does not even use the word convict or criminal. He uses the word wrongdoer. He says we must use the Probation of Offenders Act to change the mission of sentencing from punishment as it was in pre-colonial and feudal times to humanizing the offender. There is another judgment which he and Justice Chinnappa Reddy have written on the Probation of Offenders Act, where Justice Chinnappa Reddy also expresses the same sentiment, that we must understand that people who are wrongdoers are people who are like us. They laugh and they play, they have families, they have their aspirations, that they are products of the society, both good and bad. And as somebody says, but for the grace of God, we would have been could have been in that same situation if we were also given a different deck of cards by life or by fate. And therefore, Justice Krishna Iyer says we must use the Probation of Offenders Act to understand the humanity of the person who we are sentencing and ensure that our sentencing is just and has a inclination towards rehabilitation. and helping that person to reintegrate with society, restorative justice. So the very idea that a judge at the Supreme Court of India, speaking through Justice Krishna Iyer, is looking with compassion. Compassion means feeling the pain of others. It is not like sympathy. Sympathy is you have feel pain and I feel pain. That is sympathy. This is empathy, where the pain of somebody else becomes my pain. So there are many few probation cases where, with all this compassion, Justice Krishna Iyer has refused to apply the Probation of Offenders Act to convicts and to send them to jail. But he has sent them to jail with compassion, understanding their pain, understanding the pain of their family, understanding the pain of society, with a humane understanding of why he's doing what he's doing. And by doing that, he's advancing the constitutional vision of justice, which at the end of the day starts with compassion, expresses itself as Swaraj based on Satya, Ahimsa, and Antyo and Sarvodaya, and then expresses itself in legal language as equality, liberty, fraternity, dignity, and socialism, secularism, and democracy and republicanism. So this is the framework of understanding the constitutional vision of justice. We have to understand that we are dealing with human conduct and we are dealing with human beings, and these human beings are produced by society, whether it's a civil case or a criminal case. If we can approach, lawyers and judges can approach each case understanding we are dealing with human beings, and I think the constitutional vision of justice based on compassion will come alive. If we don't do that, we will go the China way. China has already created algorithms for judges. They have already started using holograms for judges based on algorithms. So you'll be sitting before a judge, and hologram image of a judge, and there will be 10 courts or 15 courts will be supervised by one human judge. But the parties will argue, and the computer technology allows this computer to recognize all the arguments, to interrupt in a very human way, like a judge saying, please hurry up, please end your argument. You just repeated it. Do you want to say that? Please don't say that. This is how this computer speaks, like a real judge, and then reaches a decision. We do not want a judicial system run by which is operated by, which is a set of computers. Why? Because it may be as intelligent, it may be as efficient or more efficient, it may be as knowledgeable or more knowledgeable than human judges, but it will never have compassion. And so by recognizing that the constitutional vision of justice is ultimately based on compassion, and what we are doing is dealing with humanity, we will avoid the Chinese example of using computers in courts to make judgments, or even the US example of standardizing judging through sentencing guidelines. You can go to programs on the internet and type in sentencing calculator, and if you're interested as judges, you will see that, and you can just enter the nature of the offense, and you will see the sentence sort of being changed as you say, with arms, without arms, with violence, without violence. The sentence will go up and down. So there are sentencing calculators which are also driven by computers. So it will be a sad day and a betrayal of our constitution if our judicial system also goes that way. And finally, what I want to say is, even if you give punishment, you do whatever you do, if your idea of justice is based on compassion, respects and advances and protects and secures these ideas of liberty, equality, fraternity, dignity, and republicanism and socialism and secularism and democracy, then the people of India will accept that idea of justice. And ultimately, the role of a justice system is to convince people that what the state is doing is correct. And unless your decisions are just, people will not accept that. And ultimately, the state will get weakened and it will collapse. And therefore, it's very important that we understand the constitutional vision of justice in the way that I've described. We approach the job that we do as an instrument to promote these values that are in the preamble based on the underlying ethical considerations that are in our mind. There are methods to do that. That is beyond the topic today. Today we are talking only of constitutional vision of justice, but I have discussed with many judicial academies what I call normative judging, how you can apply these in real life. I've hugely exceeded my time, but I want to apologize for that to Honorable Principal District Judge. But sir, with your permission, I will stop here.
Thank you, sir, for those inspiring words. May I now request our Honorable Chief Judicial Magistrate, Shri R. Sudhakant, sir, to render the vote of thanks.
Honorable District and Session Judge, Dr. Kalam Pasha sir, Srimati Anupama, Sub-Judge and Secretary, Legal Service Authority. The district judges are working in various stations in Palakkad district, sub-judges, and my brother and sister officers, members of Bar Association who are hearing this webinar through YouTube. I am privileged of getting this opportunity to extend a vote of thanks to the dignitaries as well as all the members of judicial fraternity who are attending this webinar. I know we all are very much benefited by the oration made by Sri Mohan Gopal, former Director of National Judicial Academy, Bhopal. When the term justice comes into our mind, we certainly think of it is a relate to court. It was a very interesting to get knowledge what is meant by justice in our constitution. We are benefited very much by your oration, sir. And the earnest attempt on the part of Secretary DLS under the leadership of Sri Kalam Pasha sir, in judicial members of judicial in taking effort to make the webinar a great success. We know that due to pandemic, this outbreak of COVID-19, Srimati Anupama is not in a position to use her ability to provide legal aid and the legal services, which is the objective of Kerala Legal Service Authority. Anyhow, I know she is conducting as much as she can in the field of legal service as well as legal aid. I say thanks to Anupama, and I say thanks to all members of judicial fraternity who are attending this program. Thanks.
Thank you, sir.
I think the Mohan Gopal sir, I think we can conclude for the time being. Thank you very much for your inspiring words. Thank you once more. Thanks.
Thank you, sir. And I would have been happy to get any comments or questions but I think we are done with vote of thanks and we are out of time. But
we can have five more minutes. If anybody wants to put any question to Mohan Gopal sir, I'll be happy. So that anybody wants to put any question regarding justice, the concept of justice. Constitution is mentioned as a book of compassion. Constitution is referred as a practice of compassion. Then I will put a question to sir. If none of you are putting any question.
Yes, sir.
Sir, earlier you are mentioning about this is the just use plus states mean use the right value, states the stand. The right value on which the society stands. That was the definition that the earlier gave. I remember from your earlier lecture.
Yes.
The right identifying the past human conduct. Judges are adjudicating past human conduct, and the legislature is adjudicating future human conduct. That's the difference between legislature and judiciary. We are deciding past human conduct, and we at the role of a judge is to identify justice, to identify the right value, which is the value the society wants to uphold. The judge has to identify that value and to uphold that value. Is it not justice, sir?
Yes, sir. But what I'm saying is, sir, that what is an authoritative way? You're fully right, sir. Absolutely right. But what is an authoritative way for a judge? We have now nearly 20,000 judges. How can the judges know what is the right value that society expects that judge to uphold? How can the judge know that authoritatively? So the constitution is the source that is speaking on behalf of society. Otherwise, the judge in Bihar may think something, the judge in UP may think something, Tamil Nadu may think something about, and the society in each of those places may actually have a different set of values. So how can we can only create a country, united country, and we can only keep this country together if we have across India, from Kashmir to Kanyakumari, Gujarat to Assam, we have one common idea about what is the right value that a court and a government must apply. And that, therefore, the judge can only advance the values that are in the Constitution. And the values that are in the Constitution, there are 75 values. I've done much more detailed. I didn't get into that. But all of those values can come within these Navaratna 9 values. So when you give bail, the question is, are you protecting liberty? When there is a crime that takes place, are you protecting dignity, integrity of the body, dignity of the person, and fraternity? When there is, when actions take place that are where people are attacked, there is a conflict between people, or property is taken away from people, right? Then we are these fundamental values of socialism, secularism, democracy, rule of law. Rule of law is part of democracy. So every decision we take, we must make sure that we must ask ourselves. You don't have to put it in the judgment if you don't have time, but ask ourselves that I am here to protect these values which are in the preamble. How will my decision advance that? So when Justice Krishna Iyer had to consider a decision to give probation, he actually, in one case, in this Ved Prakash case, he gave probation, which had been denied by lower courts. But he was advancing the basic constitutional ethic of humanizing, that is compassion. In fact, Justice Krishna Iyer's judgment, sir, I think you may be one of the people who have taught me this, but Justice Krishna Iyer's judgment is known as Karuna jurisprudence. Even by scholars, it is called Karuna jurisprudence because it is based on the idea of Karuna. So you can see this in his judgments, how he looks. It's an attitude with which he looks. He understands this is a human conflict. How can I do the best to protect the human being and protect others in society? Sometimes I may have to send somebody to jail for a long period of time for his sake and for the sake of society. But I'm doing it in order to protect somebody else's liberty, somebody else's dignity, somebody else's bodily integrity, humanity. So we must always ask ourselves, are we upholding these causes? So then we won't make the mistakes of taking away somebody's freedom in a mechanical way. So I'm saying, for example, I've written about this. I've spoken in other, in fact, in another state, I was asked to call to speak about this to the Judicial Academy. See, about this and other aspects, that when the police ask for custodial interrogation, and there is no justification for remanding except to question, for interrogation. Other things like interfering with the witnesses or evidence or fleeing the jurisdiction, none of those apply. Only for the purpose of interrogation. That is a violation of the constitutional explicit Article 20 right against self-incrimination. So one should, giving remand or custody purely for interrogation is a direct violation of the constitutional guarantee of liberty. Because I am not supposed to build the case against me. The police is, I can have the right to silence. I need not say anything that is incriminating to me. The police has to build up a case without my saying anything and present it before a court and convict me. But when the police comes to you and says, look, he has to cooperate. He has to build a case against himself. He's the accused. I want to take him to jail and you know what happens in jail. Intimidate him, put him in subhuman conditions. Then he will confess and he will confess and we will get the information we need. That is a violation of Article 20, paragraph 3, which says no person accused of any offense shall be compelled to be a witness against himself. That's direct language of the Constitution. Why? Because the Constitution wants to uphold liberty. And in fact, this is what Justice, this Arnab Goswami case also said. I didn't go into details. Justice Chandrachud, only 19 days ago, is emphasizing the importance of judges in the district judiciary protecting liberty, including by giving bail unless he has listed the grounds on which remand can be made, which are in the established grounds with established law. Unless those grounds are there, you cannot take away somebody's liberty. So in every case, if we understand that we are, as many Supreme Court judges have said, that the judges are sentinels on the qui vive, the guardians of constitutional values, the guardians of liberty. And the reason why the remand is being brought to the judge rather than directly the police is jailing somebody is to do a constitutional audit. Is this taking away of liberty consistent with the constitutional? So every magistrate, every district judge who considers any case is a constitutional auditor to make sure that the actions of the executive are consistent with the Constitution and to protect the constitutional rights of people. This is what Justice Chandrachud has written very powerfully, sir, in that judgment, which again, these are judgments which I'm sure that we can circulate. Maybe Madam Anupama can circulate amongst the judges also copies so that they can read them. So if we constantly bear in mind, so justice is the WHY, the why of application of law. It explains why law should be applied. Why are we doing what we're doing? Why is the court here to adjudicate? Justice gives us the WHY, the why of adjudication. That why is to promote these eternal values which are in the Constitution, which are very specific in the preamble. So if we have that as a checklist and ask ourselves, how are we protecting, securing, and promoting these values? Then I think we'll be protecting justice. And we must also bear in mind, as Justice Krishna Iyer always did, that these values are being promoted because we want to build a society based on compassion. Because now I'm saying purely personally, that I am convinced that that is the only value around which we can unite this country, because it is important to everybody in this country. We all want to live in a kind and caring and compassionate society, regardless of all our differences across this country. I've lived in 5 cities in India. I can tell you, I have found compassion in all these places, amongst all these communities. Not that there are no bad people, but the common people are full of compassion. And this is the idea of the freedom movement. And this is the real vision of the Constitution, is to build a compassionate society. So I see justice ultimately as always motivated by compassion. And the Constitution is actually, as I said, a book of compassion.
Thank you, sir. Thank you, sir.
Sir, may I go?
Yes,
may I
sir.
go?
Yes,
Sir, will it?
Yes, sir.
Sir, if compassion is followed as the guiding principle for administration of justice,
Yes.
will it be possible to do justice to all the stakeholders? See, the compassion means nothing but feeling the pain of others.
Yes.
If compassion as such is accepted as the guiding principle, is it possible for the courts to do justice to all the parties or the stakeholders in the cases disposed?
Sir,
compassion
yes.
to the accused may be to humanize him, and the compassion to the witness may be different. He may be expecting something more.
Yes, yes.
Then compassion to the system.
Sir,
so far the system is concerned, system wants to correct that wrong or to avoid the repetition of such wrongs. So will it be possible to strike a balance, a clear balance, in respect of all these stakeholders, if compassion as such is followed?
Sir, I think your question is extremely important, powerful, valid. There is no denying that. But I will just give two very brief responses to that. This is worth another long discussion. The first is, sir, when I have to see, when I make a decision, any decision, I am operating at two levels. Sir. One is there are certain norms guiding that decision. So let us say, for example, I have to award marks in an examination to students. Can I be compassionate and give 100 marks to everybody? That's not compassion. So I have to follow the norms and guidelines for that particular decision. That these are the questions, these are the expected answers, and the answers that meet those standards will get more marks than others. Definitely, we have to do that. But there is another purpose. As a teacher, let us say one of the students, I had experience like this, sir. One of the students is going to fail because that answer is bad. So I will fail that student, but I will try to understand why that student has failed. So let us say that student has failed because that morning his father died. I will not change my marks because your father died, I'll give you 100 marks. That is not compassion. I will understand this is why he failed. Then I will go to the vice chancellor or the registrar and I said, we have a case. The student has failed. He failed because his father died that morning. Is there something we can do to help him so that is there something we can do to support him? Maybe give him a re-examination. Maybe give him one more chance. That way, so compassion is to understand that when we take action, we are not, and not to think that, see, you have said, sir, very correctly, that we are giving punishment because we want to deter others. Sir, there is vast research all over the world that punishment does not have a deterrent effect. But we keep ignoring it. Why? Because most of the people we punish are very poor people. I've been talking to on the probation to jail authorities, sir. 87% of the people in Kerala jails are people who have less than bachelor's degree. Most of them are illiterate or uneducated. Most of them are from scheduled caste, minorities, OBC background. So my point is, would we take the same approach if it happened to our child? Would we want our child to be treated with compassion by the system rather than somebody else's child? So yes, we have to follow. I will never give one extra mark to a student because his father has died that morning. That's wrong. But can I find a way of understanding why he's doing badly and what can be done restorative to him? And also theories of justice, sir, are many theories of justice that Chinnappa Reddy's judgment, which also I can send all these judgments to Madam Anupama, talks about different theories of justice. We do not have a penal policy. So basically a judge cannot say really authoritatively that we have a penal policy and retribution is our penal policy. We also cannot say to a victim that, look, you must get relief from punishment of the offender. This is not possible in India. You can go to some other country where you can get that satisfaction, but not in India. And if we are not prepared to follow these ideas of compassion, sir, then we should not be judges, sir. We should do some other job. If we want to do retribution, we should do some other job. Because we want a compassionate society. The Constitution has created 20,000 judges in order to advance these ideas of compassion. We did not fight the freedom movement to create a judicial system that will give revenge and retribution and listen to the cry the cry for blood of people in society. That cry is there. But that is not why we fought the freedom movement and drove out the British who had those attitudes. So the challenge for us in the judicial, I'm now speaking as a member of the fraternity of Judicial Academy and a current member of the Supreme Court's National Judicial Academic Council. that look, the Justice D.A. Desai in his when he was chairman of the Law Commission, in the Law Commission report on judicial training, he has specifically identified this. It is the whole purpose of creating the Judicial Academy is to transform the judiciary from being an extension of the law and order machinery. I'm quoting, exactly quoting, extension of the law and order machinery to become a sentinel on the qui vive, sentinel on the alert of constitutional rights. Are we making this transition? Should we make these transitions? So what we are saying is, in India, under this constitution, although many of our officials, very powerful officials, have not accepted it, but if you look at the constitutional soul of the constitution, the idea that the victim should get solace from the punishment of the offender. So victim has to be held regardless of whether offender is found or punished. Victim has to be given full support by our society. And we are not doing that. We must do more of that. I'm strongly in favor of that. As Justice Krishna has said, the crime doer, that's the word he uses, must be humanized. They are not linked to each other, sir. They're both human beings. Today, somebody is the victim, somebody is the offender. Tomorrow, somebody else is the offender, somebody else is the victim. In all these cases, we must treat them as human beings and see how best we can help them and help others. Do what is good for them and what is good for society. That is why, and that is frankly, sir, this is what most of the judges are doing. I have heard actual descriptions of cases from judges. I've dealt with thousands of judges, sir, in the last 14 years. And I've heard stories of their compassion, which has brought tears to my eyes, sir. Many judges are, I don't know if you know this and if this is the case in Kerala, but all over the country, I find many judges are very good poets. They write wonderful poetry. And I have actually framed and put on the National Judicial Academy wall some poetry written by judges. They're very, very sensitive and compassionate people. And so I am also reflecting what I have learned from Dr. Pasha and others who have taught me, that ultimately when I say justice is compassion, this is not an idea I had before I went to the Judicial Academy and interacted with judges. I've learned this from judges, that yes, we punish, we apply the law, but we do so with a lot of compassion. Many of them, after they make a decision, I'm sure you're like that also, sir, they go back home, they cannot sleep sometimes, thinking of the cases that they've adjudicated. So this is one community, the judicial community, that I have found is a community with a high proportion of very compassionate people. And so what we are trying to do as academics is to get this accepted, recognized, people understand that this is they have understood the soul. These judges have understood the soul of the Constitution.
Sir, may I add one word?
Yes, sir. Of course, sir. Of course, sir.
To Varghese, sir, and to the magistrates also. Showing compassion means not letting the criminals go scot-free, or the crime doers scot-free. Justice Krishna also did not do like that. He was an advocate for probation. Probation of offenders is an advocate for probation. Justice Krishna is non-less. But in one case, that is Devaki versus State of Haryana, 79 Supreme Court 1948. It's a case of an immoral trafficking of a minor girl abducted for compulsion to undergo sexual trafficking. Krishna's word, it is an insulting stultification of the military legislation of Providence Act to extend its considered provisions to such anti-social specialist criminal. But Justice Krishna also used the words anti-social, criminal, etc. in required, in necessary, in requisite cases. In the fit cases, Justice Krishna refused to apply probation. And showing compassion means it is not letting the crime doer go scot-free, merely. But Justice Krishna applied with compassion on in the required cases. That to identify, that is what is the value promoting. How we can identify, that is what is Professor Mohan Gopal was saying, how the judge can identify the right value. Is it the right value which the society will uphold? Whether trafficking a minor girl for sexual abuse, whether the society will uphold such a value. Judge realize that value, such a person cannot be extended the benefit of probation. That is what is the, so it is not merely, you have to identify the value in the given facts and circumstances of the case. Only then compassion can be shown to the accused. Here, Justice Krishna did not show compassion because that is showing there is something when ill and silence is sin, not. When something is ill done, silence is sin. The judge will rise to the occasion. Justice Krishna will rise to the occasion, deny it, and that decision is reported. Why? It is a lesson to the other courts also. Don't extend probation in every case. So we have to find out which is the right value. How that is the constitution, is the guideline. That is what is the sum and substance of today's lecture, I think. Am I correct, sir?
Yes, sir. Fully correct, sir. There was another case in which Justice Krishna refused probation to a 12-year-old boy, sir, who was convicted. He refused probation for the 12-year-old child. So when we say compassion, I think it's a very important, very useful question. I'm most grateful to Honorable Judge for asking this question and bringing this aspect out. So when we say compassion, we are talking about identifying with the good values in a person, not the bad values. The good values in a person. But if those good values are not there, then there is nothing to identify with, sir. The pain has to come from the good values, not from the bad values. The pain cannot come, I could not murder more people. That is not a pain that we want to identify with, sir. We identify with the right values. Now, when we encounter a human being who, because of his social context and background, does not have any of these values that we have of ahimsa and some Antyodaya and Sarvodaya, or liberty, equality, fraternity, has no such values in his mind and in his value system, then what we can do is, sir, see whether in the jail that person can be recuperated somehow. Some psychologists can engage with that person and help to, and sometimes we may come to the conclusion it cannot be done. It cannot be done. So when we say compassion, we must understand that we have to understand, so we don't disregard the goodness in people, and we leverage and use the goodness in people as a means of justice, as a part of justice. Sir, one example I have is, so I did not get into an example, I've given enough. So find the goodness in people and protect that goodness. And the Honorable Principal District Judge, very appropriate used at the beginning, use the mind as a fertile soil and sow the seeds of goodness in that fertile soil. But if there is no fertile soil, there is no use of wasting seeds in growing anything there, sir. But if there is a fertile soil, then you plant a seed then the other thing I want to say, sir, that these values must be observed by the court and by the judge. So we must act in a compassionate way. We must act in a way that with respect and dignity. Then people will realize that these are lived values for this Indian state. So yes, sir, I'm very grateful for this question to clarify that when we assume that we are all, like we treat our own children, sir, when our children do something wrong versus some other children, even if they do something very wrong, we know that in them there is some goodness. We've seen them from the moment they were born. We know that there is some goodness in them. Yes, there's some badness has come into them because of outside influence, some other influence, some negative example, some accident, some unfortunate thing. And a good parent will say, yes, he must be held accountable. Let him be punished. But let us try to look at the goodness in him and recover that goodness in him. I'm sure many of you have seen, sir, on YouTube video, the examples of parents forgiving the murderers of their own children, because they are trying to recover the goodness in that murderer, if there is any. So that is one of that is at the heart of justice. Justice is a constructive idea, not a destructive idea. The judicial process is to build something, not destroy something. And the question to you is, do you have the imagination, the capacity to find something to build? If you have done something to build, then you have done justice. But if you have simply inflicted pain and suffering, if you simply destroyed somebody, the process, I don't mean the judge, the court, the bar, all these people, then that's not justice, that's injustice. So sometimes, and I know that I have no time, I can give you many examples of wonderful judges who discover in people that they themselves don't realize that there is a potential for goodness, a potential for a way forward. And they have brought that potential out and they've nurtured people. That is the court is a social human institution. It is not simply a disposal machine, in which case we should use a Chinese model. But we all believe that this is a book of compassion. A book of compassion is a book with human feelings. This is a human social institution where good human beings are taking care of other human beings in a good way to help to build, recover, find something good in them that we can build. That is our idea of justice. And Western ideas are all, see, in Western countries, they don't need to discuss this as part of law because they have a common substratum. That common substratum is the Christian ethic of compassion and love and forgiveness. They all share that. So they don't need to bring it so much into their judicial processes. But we since we don't have that, but we have an equivalent of that, but it's outside our judicial system, our jurisprudence, our classrooms, our courtrooms, our bar rooms. We have to bring it back in and say, look, we also have the Christian ethic itself. Christianity is also part of our country, our own traditions. So the Christian ethic, the Muslim ethic, the Sikh ethic, the Buddhist ethic, the Hindu ethics, they're all part of the positive ethics are part of our own traditions and must inform our ideas of justice. And as a practical matter, all it means is actually the job of a judge and the job of a teacher is very similar. Except that the teacher understands that the teacher is dealing with human beings, that the teacher is not a machine. All of us here have had teachers. And we remember those teachers who have not simply taken our answer paper and treated us as an answering machine, but have understood us as human beings. And what is the ultimate purpose of a court, sir? To teach society about what is right conduct. When you give every judgment, the people who are not party to that litigation, they get a signal about what conduct is considered right and wrong by this society. And so you're teachers. And through every judgment, you're teaching people what is right conduct, which will be protected, and what is wrong conduct that will be punished. If you do so in a constructive manner, in a humane manner, then I think we will be fulfilling the mission of the Constitution and the freedom movement. Where why did we practice the idea of non-violence even towards the British and others? Because we wanted to be humane and compassionate. The great tradition that we have. So yes, sir, absolutely right. Your honorable judge's point is absolutely correct. What I said should not be misunderstood as simply saying be compassionate with the wrong values. Be compassionate means find the right values, support the right values, don't destroy the right values in your anxiety inadvertently. Encourage and grow the seeds that are there of the right values, which is what very perceptibly the Honorable Principal District Judge said at the beginning.
Thank you, sir. Varghese, sir, thank you for the query which was raised, because it gave us an opportunity to listen to Mohan Gopal, sir, and our Honorable Principal District Judge to discuss the various facets connected with dispensation of justice in connection with the constitutional values. I once more thank Dr. Mohan Gopal, sir, for this enlightening session. We look forward for further sessions in future. Thank you very much, sir.
Thank you very much, and thank you, Madam Anupama, and my profound gratitude, sir, to the Principal District Judge for giving me this opportunity. And it's a great privilege to see you again, sir, after a long gap. Very great pleasure. Thank you, sir. Thank you. And thank you for the very nice vote of thanks and the very nice question that came from the Honorable Judge that permitted a very good